signing, an historic signing between the DIFC courts and the Malaysian courts, a signing of a memorandum of guidance dealing with reciprocal enforcement between our two court systems. It gives me particular pleasure to welcome His Excellency the Chief Justice of Malaysia along with his judicial and registry colleagues, as well as to welcome His Excellency Al-Khatiri, the head of the judicial system in Ras Al Khaimah, and his colleagues, and to welcome all of the judges and registry team of the DIFC courts, as well as you, our colleagues, our registered practitioners, our lawyers, and those that support us. Thank you. This evening I'm going to introduce the Chief Justice, who will then introduce the Chief Justice of Malaysia, and then the signing will take place, followed by a lecture to be given by the Chief Justice of Malaysia. Chief Justice Michael Huang, after being called to the Singapore Bar, joined Allen and Gledhill and helped to build it into Singapore's largest law firm, where he served for 10 years as head of its litigation and arbitration department. In 1991, he took on a role in Singapore equivalent to a High Court judge, and in 1997, he was one of the first 12 senior counsel, the equivalent to Queen's Counsel in the UK. He's held office as President of the Law Society of Singapore, Vice President of the International Council for Commercial Arbitration, Vice Chair of the International Bar Association's Arbitration Committee, a Council member of the International Council for Arbitration on Sport, and a member of the Permanent Court of Arbitration in The Hague. He's also Singapore's non-resident ambassador to Argentina, Chairman of the Appeals Committee of the Singapore Stock Exchange, a former board member of the Port of Singapore Authority, a former Chairman of the Ethics Committee of the Law Society of Singapore, but we know him best as the Chief Justice of the DIFC courts. Chief Justice Huang joined us as Deputy Chief Justice in 2005, became Chief Justice of the courts in 2010, and was appointed by His Highness the Ruler of Dubai as head of the DIFC's Dispute Resolution Authority in 2014. Thank you.
Good evening, everyone. Welcome to this event. As many of you here will know, the Memorandum of Guidance that we have signed with many courts around the world are a unique feature of judicial cooperation without parallel in contemporary court practice. The MOGs that we sign do not involve promises between courts. So in that sense, they differ from MOUs, Memorandum of Understanding, where each party undertakes some kind of activity and promise to the other side. What the MOGs do is to have both courts make a non-binding declaration purely for the benefit of the international business community as to what will happen when a judgment, a money judgment from one territory arrives in the courts of the other territory, and how that will be enforced and the procedure for doing so. And we have successfully signed this, as most of you here will know, with quite a number of important commercial countries around the world. So it is with particular pleasure that we welcome another country with whom we are entering into a similar memorandum of guidance. It gives me great pleasure this evening to introduce to you the Chief Justice of Malaysia, the Right Honourable Tun Arifin bin Zakaria. It's a matter of personal pleasure to me to welcome Tun Arifin as an existing member of the Malaysian Bar, having been admitted to that bar in 1969. Unfortunately, in 1972, owing to the policies of the Malaysian government, I was effectively precluded from practicing anymore in Malaysia, as now practice is confined to Malaysian citizens and permanent residents. But be that as it may, I have kept up my interest in affairs in Malaysia, particularly during my time as President of the Law Society of Singapore. quite frequently to Malaysia in that capacity, as we cooperate a lot with the Bar Council of Malaysia. Chief Justice Zakaria began his career with the Judicial and Legal Service of Malaysia before being called to the English Bar in 1980. During his illustrious career, he has served in all the relevant positions through the judicial system, first as a magistrate, then as president of the Sessions Court, which is the next level up. He has also served as legal advisor and counsel to numerous government departments. Then eventually became a judge of the High Court of Malaya, then on to the Court of Appeal. And in 2011, he then eventually ascended to the Federal Court, and which is the apex court in the Malaysian judicial system. In 2011, he became Chief Justice, succeeding Chief Justice Zaki Azmi, who we are very pleased also is here with us tonight. Since his appointment, he has worked tirelessly to increase efficiency in the Malaysian judicial system and to quicken the speed at which cases are dealt with. He also understands the value of commercial courts around the world, connecting to support the needs of business. And he has done a lot of work with his peers across the ASEAN region. Of course, Malaysia's economic ambitions extend far beyond Southeast Asia, with the country being an increasingly important player in industry and manufacturing, and a true global leader in Islamic banking. Meanwhile, bilateral trade between Malaysia and the UAE has doubled over the last decade. It's now worth an estimated $6 billion annually. In response to those strengthening business ties, the DIFC courts and the Federal Court of Malaysia have come together to establish for the first time how our two courts will interpret each other's money judgments, providing businesses with additional certainty should a contractual dispute arise. This agreement represents another significant step forward for trade ties between the UAE and Malaysia that will provide practical assistance to investors, businessmen, and lawyers in both countries. I also believe that it will mark the beginning of a fruitful relationship that will enable the sharing of judicial excellence in areas of great interest to both courts, such as efficiency and speed of justice. Now, while this is the first formal link between our two courts, I should add that at the judges level, we have had strong links with Malaysia for many years. In fact, when the first bench of the DIFC courts was established, we had a judge from Malaysia, Justice Tan Sri Siti Norma, who served the DIFC courts from 2008 to 2013. When she retired from that post, we were very fortunate to have been able to persuade Chief Justice Zaki Azmi of Malaysia, Tun Arifin's predecessor, to join the DIFC courts in 2013, and he continues to serve till today. I would now like to welcome the Right Honourable Tun Arifin bin Zakaria to sign with me the first cooperation between the DIFC courts and the Federal Court of Malaysia. So, Tun Arifin?
Yeah.
You're very So I think we'll put it together because we'll put it, yeah, and then we'll exchange the pictures. Huh? It's okay. I think you just put it into the folder.
Yeah.
I give you one and you give me one, and then we.
All right. Okay, thank you. Chief Justice. So, right. I think shall we again hold this? Wow, you smell the newness. There it is. Oh, thank you. Yeah. Thank you very much. Yes. Chief Justice, of course, is presenting me with a replication of the Palace of Justice. As Chief Justice Arifin said, he is the king.
Thank you.
Thank you very much. I'm now going to hand over this ceremony to the next stage, for which David Gallo, CEO of the Academy of Law, will take the floor.
Welcome to the Academy of Law, Lecture Series number 1, 2017. It is my great honor and privilege to introduce the Right Honorable Tun Arifin bin Zakaria, Chief Justice of Malaysia, who will speak on the topic, the complementary roles of commercial courts and arbitration. Chief Justice.
Thank you, Mr. David Gallo. Good evening, everyone present. Ladies and gentlemen, distinguished guests, it is both a pleasure and honor. It is both a pleasure, a privilege, and honor for me to be invited to deliver the opening lecture for the IFC Corps Lecture Series for 2017, particularly to such a distinguished audience this evening. I would like to begin by congratulating the organizers for conducting this relevant and successful event today. My topic for today is the complementary roles of commercial courts in arbitration. Much has been said on this topic by leading jurists and practitioners across the globe. However, I aim to analyze this topic and base my observations on my unique perspective, which stems from my role as the Chief Justice of Malaysia. The Malaysian trajectory to becoming a safe seat has happened with conscious effort and applications on the part of the judiciary to cement the symbiotic relationship between the arbitral regime and the judiciary. The arbitral landscape in Malaysia, which mirrors a great many developed dispute resolution regimes, has, with the support of the Malaysian judiciary, facilitated the growth and advancement of commercial justice. The evolution of commercial justice, both in alternative dispute development and in a more formal court setting, is reliant on the constant evolution of, inter alia, these two complementary systems. The setting up of the commercial court in Dubai is a perfect example of a need-based evolution. Although there has been criticism to the effect that this move tends to judicialize arbitration, I strongly believe that this is an initiative that can foster a stable and reliable dispute resolution regime. Chief Justice also laid a proposition that the role of courts in arbitrations are partners in a competitive collaboration. I would like to further develop this theory and state that I believe that the existing dispute resolution mechanism has reached this level of sophistication whereby competitive collaboration has now evolved into a complementary role played in the same dispute resolution regime. In fact, I would go as far as to say that the continued success of arbitration and commercial justice in any jurisdiction is heavily reliant on this symbiotic relationship between the courts and the arbitration regime. In fact, in a high-profile lecture given by Lord Thomas, a distinguished commercial judge had called for courts and arbitration to work together and for the existing relationship to be rebalanced. This relationship between the courts and the arbitral structure is critical for the development of broad and deep trust among commercial courts, arbitrators, and commercial community about the arbitral process. Thus, Chief Justice Alsop reiterated in his speech that the cooperation and partnership between the courts and the arbitral structure is essential for a jurisdiction to serve international commerce and for judicial and arbitral institutions to complement each other and to grow and succeed. It is now widely accepted that arbitration is one of the predominant modes of resolving commercial disputes, particularly cross-border commercial disputes. Consequently, this also facilitates an increase in trade and commerce in any nation. However, the success of this dispute resolution mechanism is dependent on having a judiciary that recognizes the finality of arbitral awards and subsequently aids in the enforcement of such awards. Recognizing the importance of this, the Malaysian judiciary has made great efforts and improvement in this regard. Allow me to delve into some developments that have established the judiciary's role to effectively meet the challenges of international commercial justice in the coming years. Drawing inspiration from my home jurisdiction, I've seen a rise in the significance of arbitration in Malaysia. Malaysia's approach to international arbitration is guided by the international and commercially minded outlook. In Malaysia, we have also uniquely focused on developing alternative regimes such as statutory adjudication, which is backed by the judiciary. This has been done by setting up an exclusive construction court to speedily dispose of cases. While this was modeled after the system in the United Kingdom, the Malaysian model focuses on the intricacies of the local system. We also set up new commercial court in September 2009 to fast-track commercial cases and to deliver a timely resolution of commercial disputes. The judges at the commercial courts are learned and experienced in commercial disputes and are ably assisted by judicial officers and staff at all levels. In terms of expeditious and economic disposal, the targeted timeline for disposal in commercial cases is 9 months from the date of case registration. The statistics show that the new commercial courts have performed well. It has proven to be successful and received a positive response from all stakeholders. In addition, other investment-related specialist courts such as the Intellectual Property Court, the Muamalat or Islamic Banking Court, and the Admiralty Court were also established to cater for commercial world. It is here that I must talk about the success of harmonization through the use of the UNCILTRA model law and the New York Conventions. The New York Convention has been rightly referred to as the single most important pillar on which edifice of international arbitration rests. This convention in itself has provided for enforcement and recognition of awards through the judiciary, making it mandatory for a system where the arbitral regime of a nation and its judiciary must work in tandem. Here I take a minute to encapsulate the changes and development in Malaysia that established this regime. Economic development in this globalized era is now predicated upon the success of the legal infrastructure and its ability to adapt and evolve. I do believe that these changes can be attributed to most successful jurisdiction, thereby establishing the role of judiciary and its complementary role in arbitration. It is for this reason that, unlike many other jurisdictions, both domestic and international arbitration are governed by Arbitration Act of 2005 that was subsequently revised in 2011. This act also successfully repealed the conventions on the recognition and enforcement of foreign arbitral awards 1985 and replaced it with uniform provisions of enforcement and recognition of foreign and domestic arbitral awards. The rationale behind this was far-reaching and was done with an attempt to internationalize domestic practices in line with international practices. The Act in most places adheres faithfully to the model law, deviating only to dilute or expand practices that are essential for the system prevalent in Malaysia. The scope for reference of dispute is wide and includes disputes that may arise in respect of a defined legal relationship, whether contractual or not. In a recent judgment in the case of Press Metals Sarawak Sdn Bhd and Etika Takaful Berhad, the Federal Court held that a reading of Section 8, 10, and 18 of the Arbitration Act 2005 will clearly establish the intention of Parliament to give the tribunal a wider jurisdictions. The courts also read the scope of Section 10.1 to say that unless an arbitration clause is null and void, inoperative or incapable of being performed, then the matter will be referred to arbitration. To further expand my theory today, I refer to a quote that I made in my speech in 2013, which reads, "One must recognize the fact that arbitration, albeit a form of dispute resolution, alternative to court litigation, is built on law and therefore dependent upon the law and the judicial system. In this respect, courts must assume an important role in the arbitral system in ensuring the full potential and benefits of arbitration can be achieved. I'm a strong believer in the need to constantly evolve and update the judiciary. The Malaysian judiciary therefore constantly collaborates with international professional institutions through KLCA to conduct various training courses, conferences, and programs for the judiciary. Judges also regularly sit in the courses in international arbitration to gain adequate knowledge to successfully fulfill the mandate in building an effective dispute resolution regime. All these efforts have directly translated to a situation where arbitration is viewed as part of the landscape of dispute resolution in Malaysia, as opposed to being an alternative or a competitor to commercial courts. In fact, this was recognized even before the amendment to the Arbitration Act, where in the case as early as 1996, the Malaysian High Court held that it was strike law to preserve an arbitral awards unless there has been an error of law on the face of it. The Malaysian judiciary has now adopted a pro-arbitration stand. This is illustrated in the High Court case of Pernak Abis Sdn Bhd and CCI Technologies Sdn Bhd, in which the court decided that it is not proper for the plaintiff to seek a remedy in court in the first instance where there was a specific provision for arbitration and also appropriate preliminary contractual steps for dispute resolution. The lack of judicial intervention by the Malaysian judiciary of arbitral awards is clearly illustrated in the Federal Court case of Intellect Timor, Sdn Bhd and Future Heritage, where it was held an arbitrator's award is final, binding and conclusive, and may only be challenged in exceptional circumstances. In the more recent case of the Government of India and Kern Energy India Private Limited and another, the Federal Court reiterated the principle of non-intervention and stated that the judiciary will not interfere on a matter referred to arbitration unless the decision upon the question in law is an erroneous one. I cite these cases not just to establish the importance of courts in the process of arbitration, but to re-emphasize my theory that one should no longer view arbitration as an alternative to litigation, but as an alternative form of dispute resolution, where commercial courts, domestic and international, are focusing on capacity building and innovative mechanism to strengthen the dispute resolution regime. The more appropriate terminology would be to call them complementary to each other's functions. It is time to recognize the dispute resolution regime in one broad canvas and also understand the importance of the role of commercial courts to augment, facilitate, and promote this unified system in many facets. The role of courts in the process of arbitration was succinctly put by Professor William W. Park, Professor of Law, Boston University. He said this: judicial review at the arbitral situs enhances efficient control of aberrant arbitral behavior, promoting confidence within the commercial community that arbitration will not be a lottery of erratic results. In other words, judicial provisions in its current limited form gives international arbitration a validity and confers a legitimacy on the parties' agreement and the arbitrator's award, a legitimacy that they would not otherwise enjoy. It is now time to turn to the future of this complementary role. connective technology and new technological advancements have rapidly increased the interactions of economies. The demands of market stakeholders in technology are at such a rapid pace that there is a need to not just work in collaboration, but also anticipate these changes and evolve within the context. Economic integration is the key word today. Initiatives such as the One Belt, One Road and the ASEAN Economic Community are all initiatives that rest on this principle. The One Belt, One Road initiative is a strategic vision that focuses on connectivity and cooperation among countries. While arbitration will be a mainstay for dispute resolution, such integration will also require the need for judicial assistance in a more dynamic way for better recognition and enforcement of not just arbitral awards, but also foreign court judgments and other commercial court judgments. It will also see the advance of other unique and innovative methods of dispute resolution, which will need the proactive development of the judiciary to be successful. This future will also see the need to evolve judicial infrastructure to support such free trade. This does not necessarily imply development of an international commercial court for each region, but can also be achieved by existing commercial courts in tandem with international commercial courts. Innovation is also key, for there will be a need to anticipate the local demands and nature of the market of different regions in this era of economic integrations. For example, rules such as the arbitration rules, which harmonize Sharia principle with international commercial arbitration, will become relevant. However, its success will depend on courts understanding the basis of these rules and its relevance in the economic milieu. I'm of the opinion that the distinguishing factor or the solution does not merely lie in the establishment of international commercial courts, but in procedural innovations and use of technology by existing domestic courts too, in taking on a larger and more dynamic role in the dispute resolution mechanism. The evolution of domestic commercial courts should be enhanced by taking into consideration lessons and challenges faced by stakeholders in the judiciary. I hasten to add that there can be no one-size-fits-all in this, and is to be done with due diligence and input from all stakeholders. Lord Thomas, Chief Justice of England and Wales, rightly stated that transformation and changes should be made on the markets, motivated by judge-led reform. I add to this a need to focus on innovation and sustainable development. By innovation, I do not just refer to innovation of court procedures in the form of flexible rules, but also other innovative measures by the commercial courts to facilitate the use of dispute resolution. This could range from modification of procedural aspects to use of technology for flexibility. The role of court is crucial to the sustainability of dispute resolution regimes in any country. The Honorable Chief Justice Marilyn Warren, AC, and the Honorable Justice Clyde Croft, in the talk titled Looking Beyond the New York Conventions, has spoken of the developing international legislative architecture. I find the use of this term most appropriate, as I believe in the coming years the relevance of commercial courts in dispute resolution will go beyond the realms of traditional enforcement. An indicator of this is the Hague Choice of Court Convention, which came into force on the 1st of October 2015. This is aimed at effectiveness of choice of court agreements. Innovations such as this, or model on this, will be essential for the success of economic integrations. This innovation will become particularly relevant in overcoming challenges that may arise in light of such developments, such as the recent example of restrictions on the Dubai International Finance Court to act as a conduit jurisdiction for the enforcement of arbitral awards rendered in mainland Dubai. Once again, I come back to the crux of all the pivotal notion behind my talk today. The role of commercial courts and arbitration should not just be complementary, but should be viewed within the same dispute resolution landscape and not as alternative. Innovation is also key, for there will be a need to anticipate the local demands and nature of the markets of different regions in this era of economic integration. Another key factor to bear in mind in this evolutionary process is to take into consideration the role of commercial courts in other forms of dispute resolution in coming years. An example closer to home that I wish to refer to again is the setting up of our statutory adjudication regime under the Construction Industry Payment and Adjudication Act 2012. This mechanism has become very successful in handling payments, claims, and easing the cash flow crisis in the construction industry. Specialist construction courts in Malaysia also successfully validate this process by exercising judicial restraint. In fact, to go a step further, to help the construction industry, I launched a Practice Direction number 4 of 2016, which provides for court-annexed mediation for disputes. The court-annexed mediation has many benefits. It is a just, expeditious, and economical way of disposing cases. Mediation is very informal in nature, where parties could speak to the judges directly in the language which they are conversant. In Malaysia, court-annexed mediation offers free mediation service, where judges at any level of court sit as mediators to facilitate and assist the disputing parties to resolve their dispute. The courts have supported the use of mediation as alternative dispute resolution to dispose cases. This scheme has seen great success and is yet another example of how international principles can be appropriately absorbed into the local system for dispute resolution. The purpose achieved by doing this goes beyond helping the domestic economy. It creates and promulgates a culture of effective dispute resolution, which will make the transition for future developments easier and more effective. Once again, I hasten to add that the only way to overcome challenges is through structured reform, continuous capacity building, and a focus on sustainable evolution. I speak from first-hand experience, where I have witnessed the setting up of construction court in Malaysia, having made the process more efficient and effective. Professor Jane Paulson once stated, the great paradox of arbitration is that it seeks the cooperation of the very public authorities from which it wants to free itself. It is safe to say that arbitration and the judiciary have evolved enough to state that this is no longer a paradox. It has always been the case that even an alternative to court litigation must be firmly rooted in the rule of law. The common fabric that runs across this mechanism of dispute resolution and all other existing or future innovation will be this fabric. I have laid out some of these changes and analyzed them from the perspective of a member of the judiciary. I also wish to state that I do not view myself just as a member of the judiciary, but as a member of this dispute resolution framework in Malaysia. All this translates to an inclusive system of dispute resolution. Arbitration and commercial courts do not and ought not to function entirely independently of each other. Acceptance of this notion becomes pivotal for the success of a regime. Judicial involvement in the arbitral process no longer comes with a negative connotation, but instead a more positive and necessary involvement in keeping with the times. It is time for a new and modern approach to the role of courts in arbitration while preserving the fundamentals of our past and progressing towards the future. I would like to conclude by once again thanking the organizers for putting together this lecture series and by stating that the role of courts in arbitration is definitely complementary. There is no longer any divide, but just a unified dispute resolution regime with multiple facets to facilitate commerce, economic integration, and rapid globalization within the framework of law. The role of commercial courts, domestic and international courts, will undergo a sea change in the coming years, but will remain rooted in being the guardian of justice. Ladies and gentlemen, thank you very much for listening.
Thank you, Chief Justice Zakaria. We have about 20 minutes for Q&A, so if anyone has any questions, Jeff has the microphone.
while we have questions coming from the floor, let me just start. I am delighted that Chief Justice Zakaria has made such a forthright and unequivocal statement of the pro-arbitration attitude of the Malaysian courts. This is really quite important when investors look at doing business in particular countries which might well have passed the stage of emerging, but where historically investors may have been a bit shy of going in because of some doubts about their ability to choose a dispute resolution process which they find is a satisfactory compromise to the needs of the overseas investors with the needs of the counterparty in another country. And for people who are compiling rankings in terms of most comfortable place to do business in, they look at things like the classification of a country as being pro-arbitration or not, because say what you like, generally speaking, overseas businessmen and investors do regard the ability to have effective arbitration as a highly useful plus factor in determining whether or not they want to do business in that particular country. And with the now clear attitude of the Malaysian courts in encouraging arbitration, this is coming parallel to the rapid rise of Kuala Lumpur as an international arbitration center. And certainly it is now recognized as being one of the leading arbitration centers in Asia, and if not in the world. So against that background, let me just ask Chief Justice Zakaria a question. Some of the more established countries which have already are well accepted as being pro-arbitration centers, such as England and Wales, Singapore, Hong Kong, their courts have gone to the stage where they say in no uncertain terms that if an application concerned with arbitration comes to court and a party tries somehow to impede the progress of an arbitration, then not only will they dismiss it quite quickly, but they will also impose the maximum scale of costs, which in England, Singapore, and I believe Hong Kong is now called indemnity costs. I'm not sure whether in Malaysia you have indemnity costs or you're still working on solicitor and client and party and party. In Australia, strangely, they have not yet quite settled this definitely. There are some courts which have done it, other courts are not so sure. What is the position now in Malaysia? Is there any court judgment that says that if you come and waste time on a plainly hopeless challenge to arbitration, we will deal with you accordingly by imposing this higher level of costs?
So far, not that I know of, we have not come to that stage, but a quick disposal of such an application will happen in Malaysia, and it is our policy to dispose this kind of application as quickly as possible in order for the arbitration to proceed. So we don't want the...
I think you're not being heard so well. You want to maybe bring it up a bit further?
Well,
Hold it
yeah.
to your You just hold it up.
Similarly, in Malaysia, we have that approach in the sense that if any applications try to impede the progress of arbitration, we'll try and deal with the matter as quickly as possible and dispose the matter and proceed with arbitrations. So, but as far as cost is concerned, I think we have not come to that stage yet. Probably we'll consider what is practiced in other jurisdictions when the time comes. But this again open to what I call this application by the lawyers. Lawyers have to ask for it, let the court will react and consider such applications. But there's no such court decision yet. Thank you.
Anyone else from the floor? I mean, this is a highly interesting subject. Yes, Judge Chamlan.
I will raise my voice.
I don't know. There's a microphone.
From my observation, there's some jurisdiction like Australia is India. They designated a Supreme Court or a federal court to deal with international arbitration or in terms of recognition and enforcement of the international arbitration law. So what's the status in Malaysia? Are they like a designated special court to deal with international arbitration award? Is it the federal court or the local court or like a division, a special division to deal with that? Or, because some jurisdictions they do have designation.
Any applications, because it relates to commercial, so we have what we call the commercial courts in Malaysia. These are designated courts to deal with commercial matters, which includes applications with regard to arbitration and so forth. So there's dedicated court, if the answer is, but at the High Court. But there's no specialist court at the Court of Appeal or the Federal Court. But what we do is to expedite disposal. In the event of an appeal, we always have this fast-track appeal from the High Court to the Court of Appeal and right to the Federal Court.
But that means in Malaysia there is no difference when it comes to enforcement between international arbitration.
Yes, it's the same. It's under our laws will give same recognition.
The other thing which is interesting about what Chief Justice Arifin has said is mentioning the Hague Convention on Choice of Court. What are prospects like in Malaysia joining that convention?
Well, I mentioned it as a matter of completing my paper on this, but so far it is a matter of policy of the government.
Yeah,
so
yeah.
It's not for the court to take the initiative in this area. But I suppose we'll look into it because if we want to support arbitration in the country or promote arbitration process in the country, I think we should and join these conventions.
Well, for the benefit of those here, there is actually another project on which goes beyond choice of courts. There is another Hague Convention project which actually is seeking to have a convention just on straight recognition of foreign judgments. Because the choice of courts right now is, if you have a choice of court provision in your contract, then the countries who sign up for this convention will enforce in accordance with the agreement. But now we want to go one step further and seeing, and there's a working group already dealing with this now. So I just learned this a few days ago. So that's for the medium term. And even in the present scenario, foreign judgments can actually travel further than one thinks, because traditionally the big selling point of arbitration is that arbitration is more, an arbitration award is more transportable than your normal judgment. Because of the New York Convention, at the last count, about 156 countries have signed up for the convention. But you know, the enforceability of judgments is actually not that far behind, mainly because of the unity of the common law countries in ascribing to the universality of recognition of foreign judgment. This is what our MOGs are based on. And many people think that judgments of courts don't travel unless there's some kind of a treaty. So people are looking for the equivalent in litigation of the New York Convention. But they overlook the fact that actually, certainly within the common law countries, you don't need the convention because you have the doctrine of common law doctrine that it is mandatory for all courts to recognize and enforce judgments of other countries, not necessarily common law countries, and without regard for reciprocity. And you have got 51 countries in the Commonwealth. Now that's a bit of a tricky figure because not every country in the Commonwealth necessarily adopts the common law position because recently the Commonwealth has admitted certain countries which were not former British colonies and have different civil law traditions and they may or may not now adopt the common law position. For example, this is a trick question. How many countries in the Commonwealth were not former British colonies? Well, just for example, there is Rwanda, which was formerly Belgian, Mozambique, which was formerly Portuguese, Mauritius, which was formerly French. And they all had the European systems. But I hear that they are gradually changing over to common law, so we don't know what their status is right now. On the other hand, there are countries which used to be part of the British Empire and chose not to go into the Commonwealth, but they inherited the common law system, like Ireland. I just learned this morning, Sudan, from where Chief Justice Ali Imam comes from, also had British law. So it's likely that countries like that will also have. So if you add up all of that, and don't forget you have got the 51 states, sorry, I won't say 51 states, 50 states of the USA, which are all common law. And why I drop out the one state is because when we signed our MOG with the Chief Justice of the Southern District of New York, I said, when you sign with you, does that mean to say our judgments are enforceable throughout the whole of the USA? And she said, I can't vouch for Louisiana. Actually, it might well be that Louisiana will recognize it because we have now learned in our experience in negotiating with some civil law countries that actually civil law countries all have civil procedure codes which all contain some provision for recognition of foreign judgments. It's only a question of complying with those conditions. And usually there are about 4 conditions, and usually 3 out of the 4 are not difficult to comply with for most judgments. But anyway, our research is still going into this. I'm just rambling on just to keep things going to see if anybody else wants to chip in. I think Justice David Steele wants to say something. I tremble in fear that he's going to contradict me.
As the 2 selling points, it seems to me.
Yeah.
First, the New York Convention, about which we've spoken quite a bit. But the attraction of the New York Convention is dependent, in fact, on courts.
Yeah.
Because unless there's enforcement,
Right.
it doesn't really matter whether the New York Convention works. The New York Convention has its limited ability on the enforcing courts to question the validity of the awards, including, amongst other things, the slightly uncertain topic of public policy. My first question is really this. In Malaysia, is the position that the New York Convention and the limitations on the entitlement to attack the validity of the award as set out in the convention, or is it broader? And have the courts, in fact, defined public policy in a way which perhaps doesn't coincide with the views of other states? The second way in which arbitration is sold, if I may put it that way, is to say, well, court proceedings are very expensive and very slow. I have to confess my impression is that arbitration is even more expensive and even slower.
Yes.
What, if anything, can state courts do in husbanding arbitration, nonetheless, to try and impose some kind of discipline on time and money?
On the arbitrators, is it? So far, well, of course, in Malaysia, the second question posed by, as far as the Malaysian court is concerned, the second question was the.
First one was about the convention.
Yeah.
Does Malaysia apply the limitation on the right to challenge, and in particular adopt a relatively restrictive approach to public policy? Second question, what can the courts do about arbitrations which are slow and expensive?
There's nothing much we can do as far as the second question is concerned, because it's party's choice to go for arbitrations. And as far as the first question is concerned, we try as much as possible in Malaysia to comply with the terms and conditions of New York conventions, and we have it legislated into our 2011 Act to comply with international conventions. So that's the policy in that sense. As far as the government is concerned, we're trying to promote arbitration in Malaysia, and also to allow enforcement of the award from other jurisdictions. But as far as cost is concerned, I think it's just like anywhere else in Malaysia. I think the cost of arbitration is much higher. And in fact now, parties prefer to go to court because of our speed of disposals, not only in ordinary commercial cases, but also we have specialist court like the what do you call it, the construction courts, which we deal with construction industries, and they are very fast in disposing cases. So there are less and less, arbitration is less popular now, I think, in years to come. It's a big challenge to the arbitration community.
My
Yes, sorry.
question for both esteemed panelists is there any cases now looked at in front of Malaysian court or the IFC that are investors from Malaysia or UAE or investors in UAE are involved in these cases, and what type of these disputes are looking at both the IFC and Malaysian court? Is there any cases now you can mention to us to learn what type of disputes are between Malaysia and UAE are looked at now?
Sorry, the sound system wasn't very good. Could you repeat that question again?
Is there any cases now looked in Malaysian courts?
In the Malaysian courts?
In Malaysian courts that are investors from UAE or UAE national are involved?
From here.
Yeah, you're saying that are there cases in Malaysia where UAE nationals are involved?
All the nationals, investors from UAE.
From UAE?
Definitely not any cases from the IFC.
No, not from DIC. But there are cases in Singapore involving people from UAE.
Malaysia, I'm not aware of any cases from UAE involving parties from UAE in Malaysia. Not at the moment.
So everything is safe between Malaysia and UAE in the investment side and trade side.
Sorry, what was that?
It is very safe now. No disputes came to rise between Malaysia and UAE in investment or whatsoever. Everybody is having his own rights without going to the courts.
Well, there actually is one quite famous arbitration going on between a UAE company and a Malaysian company. It's all over the newspapers.
But not in Malaysia.
Yeah, actually, they're not arbitrating in Malaysia.
No, not in Malaysia.
Right. I mean, they are arbitrating in the third
Yeah.
party. It involves an Abu Dhabi party
Right.
and a very famous or infamous Malaysian company.
Just following on that, say, we both know these two entities are sovereign-linked entities and having an arbitration somewhere in Europe. What will happen with
It's
this,
better because people behind can hear you.
with this signing of this memorandum of guidance, on the assumption that the parties would reach arbitration is completed, say for example in England, and the enforcement of the award will need to take place. How would that, coming back to Mr. Steele's question, public policy, how would the Malaysian court be dealing with that? Because that this does in some way affect public policy once the enforcement will come to Malaysia.
Well, my answer is simple. If there is an award made by an arbitration from a foreign jurisdiction, in a foreign jurisdiction, because under the New York Convention, we have to recognize that. And that's the Malaysian, the current position in Malaysia, will enforce it, despite how harsh it may be.
No, to be, I'm not trying to take anything away from Malaysia, but it is true that the attitude of the Malaysian courts have changed over the years towards international arbitration. Because I give lectures on this all the time, and there used to be a case that I would point to, at the High Court level to be fair, where there was a dispute about a sale of some, I don't know whether it was arms or something, from Israel. All right. So then that contract came for an arbitration. There was an award in favor of the Israeli party, and it came for enforcement. And somehow at the level of the High Court judge, there was a reason why he said he could enforce it. But he said if he had to decide this, he would have found that that contract was against public policy because it was against Malaysia's foreign policy to deal with Israel. You see, so this you normally would classically criticize it for confusing foreign policy with public policy. And the Indians have a similar problem because they confuse foreign exchange policy with public policy and so on and so forth. So these are issues of domestic policy and not international public policy. Come and attend the conference at the one and only Mirage on Wednesday. You will hear more of this.
Any more questions?
I would just like to share my observation being a practitioner in private sector in Kuala Lumpur. Indeed, arbitration was somewhat, trailing behind, say, compared to Singapore and Hong Kong or Malaysia. But I think over the last 3-4 years, I think the sector, arbitration as a process of dispute resolution has gained more prominence. As a lot of more concerted efforts undertaken by Kuala Lumpur Regional Centre for Arbitration. In the past, even when I was working for big multinational corporations advising cross-border transactions, people tend to do arbitrations. People tend to sort out dispute mechanisms via arbitration. Because the arbitration was somewhat not as advanced in Kuala Lumpur, the only choice at that time was somewhat the Social Court. As arbitration center gains more prominent, basically people tend to go to arbitration. But at the same time, the court system has advanced itself to a level where case disposal has taken much other time to dispose. And of late, the general tendency is that people are saying, given the cost, the expression of the cost in arbitration, people are beginning to ask questions. When they craft dispute mechanism clause in the agreement whether or not they should submit themselves to the arbitration courts as arbiter, or they should settle through an arbitration. So I think as the court continues to improve themselves in the process of disposing cases, I think arbitration, except for those really big multinational corporations who can afford the cost, I was recently involved in one contract involving an international company who has got an office in Dubai with a Malaysian entity, in a commercial transaction. So the issue of whether or not they should be submitting themselves to Malaysian court or arbitration is a real issue. But I think the cost factor is something that multinational corporations, will consider. I think one thing for certain is that Dubai International Financial Center as a forum for dispute, especially involving companies having presence in the center, is something that I think basically, I suppose the center needs to market themselves. Nothing much has been done so far, at least among the practitioners in Malaysia. The most famous center for arbitration in Asia would be LCIA or Singapore Center of Arbitration or Hong Kong. But people, especially, are concerned about Hong Kong because of the so-called perceived lack of independence from the authority of China. So I think, in as much as arbitration has gained more prominence in Malaysia, but the effectiveness of the court system in Malaysia has also rendered the parties to commercial, contracts to be somewhat, to be somewhat at the crossroad whether or not they want to opt for arbitration or for this thing. The compelling factor for them to opt for Malaysian court system, for as long as the court system continues to improve the efficiency, is that there is no cost involved, because cost is all borne by the court, the court systems. Thank you very much.
Anyone want to add in any last words? Just to respond about costs. There is no guarantee that costs in arbitration are more than costs in litigation. Let's say in Malaysia, maybe. Because if you litigate in Malaysia, you have to use Malaysian lawyers. And then you pay Malaysian lawyers' fees. If you go to international arbitration, if you still use the same Malaysian lawyers, theoretically, there should be no difference. In fact, if the arbitration finishes quicker, then theoretically, the cost should be less. You have to add on the costs of the arbitrators, but as a rule, statistically, the ratio of costs of arbitrators to the total cost spent would be 20% against 80% for legal costs and experts' costs and so on. So when it's truly international and people have to fly, not only their whole team, but the experts, and then you rent, and pay hotel and all that. If you add all of that on, then it could be quite expensive. But the rest of it is all which lawyers do you employ, and whether they are in court or in arbitration, usually they charge you the same rates. So it's not a fixed rule. Yes. Alec Emerson.
Hi. Thank you very much for introducing me. The talk about costs just got me thinking about new rules that's being introduced by CIAC and ICC and also others for expedited arbitration. And as we have two eminent judges sitting in front of us, I would like to ask a question as to whether you feel there may be any issues that result from award enforcement in cases which have been subject to expedited proceedings, bearing in mind that in these current rules the parties have not actually agreed but are being forced by the format of the rules to accept that for small claims under $2 million, in the case of ICC and I can't remember CIAC, they're forced to agree, or forced to accept a sole arbitrator expedited process, and that even if they've agreed 3 arbitrators in their contract, do you think there could be issues on international enforcement in relation to due process?
There is a Singapore High Court case that deals exactly with this point. And you see, under the SIAC rules, the decision to have expedited proceedings is taken by the centre. And when you sign the arbitration clause, you sign up for the rules as they exist. The rules allow for one party or the centre itself to decide that this is a small case, it can be dealt with quite quickly, and they then say, we will convert this into an expedited arbitration. When they convert it to the expedited arbitration, the chairman of the SIAC has the power then to say, I override your arbitration clause, you say 3 arbitrators, I say 1, and he fixes it at 1. So this was challenged in the Singapore High Court, and the Singapore High Court says, you signed up for the SIAC rules with all of its ramifications and all of its possibilities. So this was done legitimately under the rules, so you have to stand by it unless you wanted to contract out of that part of it. If you didn't like it, you should have contracted out of it at the beginning. Okay? Have we satisfied everyone's curiosity? No, you're standing up again.
I think that's fine in a sophisticated court, and I think we find the same results in England, in Hong Kong, I'm based here in the IFC. But I'm not sure that that's so in lots of other jurisdictions. That's really my...
Sorry, your concern is about ICC or Malaysia?
No, my concern was that whilst the interpretation that the Singapore courts have given to expedited proceedings being within the agreements of the parties because it's in the rules, may not necessarily be the line that's followed in less sophisticated courts. That's what I'm saying.
Well, actually, the more realistic issue is where the tribunal itself starts to become super efficient and cut down the timelines for filing submissions, filing witness statements, and so on. And then you're going to get this tension which exists between due process and efficiency, time and cost efficiency. And the lawyers will bellyache, and then they will complain about their holidays, their religious festivals, and sometimes, in all honesty, we've got this experience that certain counsel will represent to some unknowing arbitrator that a certain holiday actually can stretch for much longer than it actually takes. All of these things. And then at the end of the day, if they are cut short and they lose the case, then they have nothing else. They'll say, well, there was a failure of due process and I challenge the award on that ground. So you need a strong court again to see through all of this. Chief Justice, do you have a view on that?
I associate myself with what you have said, because we have not had the opportunity of hearing that kind of case in Malaysia.
And also it's quite difficult because nowadays most of the newer versions of the institutional rules do specifically say that tribunals must pay attention to time and cost efficiency. So they've got the justification there. Having said that, I must again pull my friend's leg here. And this is actually quite an interesting question. This is a mixture of the model law and the New York Convention. Now, under the model law, if you want to set aside, you have to set aside within 3 months of the award. You must file your application for setting aside 3 months. And in Singapore, we have a decision where the person filed, the person who wanted to set aside, filed within 3 months and gave his grounds. Then after the 3 months, he changed his grounds and wanted to put in additional grounds. The court said, no, 3 months is 3 months, and the cut-off point is there. You can't introduce new grounds anymore. Then recently there was a case in Malaysia, and this is quite interesting. There was an arbitration against the Laos government, the Laotian government. It went against the Laotian government. And then the Laotian government let things pass, and about 15 months or so later made an application to set aside. So the party who won the case said, no, you are out of time, it's 3 months. Now it's more than a year. So the High Court judge, as I remember, he interpreted the Malaysian arbitration law, which is based on model law, same law as in Singapore, to say, no, first of all, the model law must be read in the light of our domestic law. Our domestic law says in all statutes, the court always has power to extend time, which is provided in any statute, right? And in this case, then I have to consider whether or not there's a good reason for the delay. And he says, well, you know, Laos is a government. Governments don't move fast. So, and why did you not apply? So the Laotian government said, well, as soon as we lost the case, the party who won then went around the world trying to enforce it. So we were fighting fires all around the world, and our lawyer forgot about the home base to set aside. And the High Court judge gave leave. I think he set aside and allowed them to argue that point. So it's gone to it went on appeal. I don't know what happened on appeal. It hasn't come to you yet. Okay, so that's an issue. By the way, and in Hong Kong, there was another case where a Hong Kong judge, again, was quoted the Singapore case, 3 months is 3 months. She says, no, 3 months is not 3 months. In this case, she allowed setting aside 8.5 years after the original award. Why 8.5 years? Because for 8 of those years, the respondent, who was an individual, was in jail.
Thank you, Chief Justices. And now, on behalf of the Academy of Law, Chief Justice Wong will present Chief Justice Zakaria with a gift expressing the Academy's appreciation for this great lecture tonight. Thank you very much.
Thank you so much.
And thanks to all of you. Have a great evening.
So, thank you. A good time to go.
Yeah.
Hope you enjoyed that.
Yes.
Thank you,
You learn a
gentlemen.
lot from it.
Yeah, just make sure that who's Kimberly?
This one,
Is Kim looking up?
Yeah.
Just to make sure that we've got signed papers. Yeah. Who's keeping this? Is it Kim or? Okay.
This is the fully signed one of ours.
Yeah, this so you have to give one copy. You want to take one copy now? One copy. But we date it, or we can date it ourselves.
Do we need a photo in front of the banner?
Yes, sure. Yeah, we'll set.
Should we send this across?